Jurors are irrational. Humans fundamentally are irrational. Now, this doesn't mean we're crazy. It just means that our decision-making process doesn't work like that you think that it works. The law of least effort. And here's what it says. You'll stop thinking about anything at the first opportunity you think you can. And if you don't think you got to think about it, you won't. The more complex the question, the faster you will stop thinking about it. If I ask you a question and you answer yes to that question, you are statistically more likely to say yes to the next question, regardless of what it is.
Welcome and thank you for joining us for another Justia webinar. My name is Nina and I'll be the moderator for today. Now to kick things off, I want to go ahead and introduce our speaker, Jake McKenzie. Jake McKenzie, CEO of Intermark Group and Intermark Legal, uses his expertise in psychology to craft persuasive strategies that influence jurors' thoughts, emotions, and actions, giving cases an extraordinary edge. With a background in psychology and political science from Vanderbilt University and an MPPM from Birmingham Southern College, Jake has shaped national and international litigation strategies, contributing to successful settlements, including large-scale outcomes. The webinar presentation that you're about to watch will be approximately 1 hour, and at the end of the presentation, Jake will be taking audience questions. If you have a question that comes up that you'd like to submit, you can click the Q&A button in the control panel at the bottom of your screen, send it on over, and we will answer those once the presentation is complete. Now, without further ado, here is Jake to discuss advanced voir dire techniques, winning the case before it starts.
Thank you, Nina. I appreciate that. Hi, everybody. I'm Jake McKenzie with Intermark Legal. My background is in psychology, and that's what we're going to talk about today. It's really about identifying, shaping human behavior. But it starts with a much more simple premise. Have you ever wondered what makes a great litigator? Go talk to the other folks at your firm, interview the people that have done this successfully, and ask them what makes them great. One of the most frequent answers you're going to get is that I was really good at picking juries. And they mean it a little funny. It's a little trite, but there is so much truth in that notion because often cases boil down to the mixture of who is on the panel, even more than the quality of our argumentation or the experts that we have or the quality of testimony or even the judge that we have. Yet it is the thing that gets practiced least and often gets ignored until the last moment. So it deserves a little more attention, and that's what we're going to spend a little time talking about today. So we will begin with the basics, and I'm going to give you an overview of Intermark and who we are very briefly. Intermark Legal offers consulting services related to trial and preparation, everything from understanding your jury pool with market research, online surveys, focus group and mocks, to message crafting, witness prep, jury planning, and post-trial. But we're going to discuss one very specific thing today about selecting and influencing a jury, the voir dire section or voir dire, depending on what section of the country you are from. So we're going to begin with one simple premise. That premise is jurors are irrational. Now, if you've seen me talk before or you have been a fan of psychology, you know that humans fundamentally are irrational. Now, this doesn't mean we're crazy. It just means that our decision-making process doesn't work like that you think that it works. So let's begin there. Well, we now know that all of the teachings that we had in college in Economics 101 about how people make decisions being hyper-rational is not true, or not really true. In fact, about 15 years ago, they gave the Nobel Prize to a gentleman by the name of Dr. Daniel Kahneman, and he won it for illustrating there's not one decision-making system in the brain, there's two. I'll give you a brief overview. System 2 is the one that the economists always told us about, where you can be super rational and you can weigh through evidence and facts and testimony and pros and cons and come up with an outcome that makes sense and is logical. Here's the kicker. We don't like using it. Why do we not like using it? Well, Kahneman illustrated that it is, he called it effortful. What he meant is that it burns physical calories. And you may not know this, but about 20% of today's entire caloric burn is going to be spent just with you thinking. The brain is a hog when it comes to burning calories. And as a result, it has developed systems to be lazy. It tries not to think unless it feels like it really needs to. So if you got to sit down and do trial prep or argumentation or something critically important, you'll do that, but you'll try to do it efficiently. And when you get done with it, you'll be exhausted. But what does this mean for jurors? It means they're going to take great pains at an irrational level to avoid thinking. They're looking for simple answers. They're going to use this other system that you may not be familiar with. Kahneman called it System 1, and I want you to think about it as the automated system. And here's how it functions. If I ask you any question, System 1 immediately says, hey, here's an answer. Is this what you mean? And here's a couple of things you need to know about it. And it functions off of everything from the questions like, hey, what do you want for lunch? What are you going to wear today? Do you think this defendant is guilty? And lots of other sub questions. The kicker is that it happens without your awareness nor permission. That's going to be a major component when we get to jury selection, because what it means is that a lot of our decision making, and neuropsychology tells us that well over 98% of all the decisions you'll make over the course of the day are made with System 1. You are blind to the fact that it made that decision or how it made that decision. And that's going to be critical to us understanding of how we can get good information out of prospective jurors, so we know who the good jurors are and who the bad jurors are. So let's dig in a little bit more. Example of System 1 decision making, a fast decision making, if you will. It's looking for simple answers to complex questions, such as who's at fault? Are they guilty? It's a great example of something where the brain will look for a highly emotional, simple decision. And System 1 will often make those decisions. So as you're structuring your argumentation, we need to be leaning into System 1 decision making. But the brain can't do that with everything, because we're going to ask the jury some questions that are more complex, such as what is the value of a human life? How long should this person spend in prison? Or other questions that don't have a simple answer, and will force it to use System 2, kind of that slow decision-making process. But that System 1, System 2 decision-making process has major implications. I give you an example. If I were to ask you very quickly, what is 2 plus 2? Very quickly, your brain said, it's 4. Now, what's remarkable is nobody here did the math. In fact, had I said, do not do the math, you would have been unable to, because System 1 is immediately going to serve you an answer. You've been programming your brain since you were 3 years old that 2 plus 2 equals 4. It's a great example of how System 1 decision-making works. It serves up an answer, and you don't even really know how you got there. It just served it up for you. Now, let me show you how System 2 works, the slow process. If I were to ask you, what is 17 times 12? Oh, you just had two very different thoughts. The first thought you had is, I know how to do that. And some of you quickly got to the answer of 204. The second thought you had is, but I don't want to. We're on a webinar. He can't see me. He's not going to call me out. It won't be embarrassing. It's fine. In fact, when I ask this question in large groups, about 95% of people opt out of doing the math, which is really the point of this exercise. Why do we opt out of doing this? This math is not much more complex than the other one, but it does require us to think. And when we are asked to think, a new law kicks in psychology that's fundamental to understanding how juries function. It's called the law of least effort. And here's what it says. You'll stop thinking about anything at the first opportunity you think you can. And if you don't think you got to think about it, you won't. And there's a corollary to it that's going to blow your mind. The corollary says the more complex the question, the faster you will stop thinking about it. And let that settle in for a moment and think about the cases that you're currently working on. Are they simple? Are they complex? Most of them are complex. They're going to require expert witnesses. They're going to be about a topic that most of us aren't familiar with, or the features of the case are more complex. We're going to ask people to think. But we know that jurors are going to want to spend as little time thinking as possible, because remember, that part of our brain is fundamentally lazy because we're trying to conserve calories. And that has implications both for how we adjudicate a case, but also how we select juries. So understanding the law of least effort is important. So let's pivot to that. Let's get down to selecting the right jury, and what does that mean? Well, ideally, it means that we are selecting a full panel of juries, whether that means 6 jurors or 12 jurors, depending on your jurisdiction, of folks that are like-minded. But it can also mean that the wrong jury might simply have one person on it that feels differently than our case, particularly if we're the plaintiffs, because one person can sully the entire pool. Now, the reality is we want to pick an entire panel of good folks, but most cases boil down to 1 or 2 jurors. Chances are your case is not getting to trial unless you walk in the door winning about 80+% of the jurors, which means we've got to get good at identifying those 1 to 2 jurors that may get onto the jury that affect things. And it also means we've got to learn to persuade those 1 to 2 jurors that may affect the outcome of the case. And that applies no matter if we're the plaintiffs or if we're running the defense. Those 1 to 2 jurors are who we're structuring everything to talk to. So what is the goal of voir dire? It is 1, to select the right jurors, and 2, predispose them to voting for you. Now, so we're going to break each of these down independently, and we probably give most of our mental energy as lawyers into the first category. How do we select good jurors? But we forget that every time we ask them a question or interacting with them, we're beginning to shape how they're going to vote in the final outcome. So we got to get good at predisposing them to vote for us while we're selecting. So we're going to talk about them independently, but we got to do it at the same time. So let's begin by looking at how we do juror selection. How do we select the right jurors? Let's start with another psychological principle called the egocentricity bias. And the egocentricity bias simply says that I believe everybody thinks like I do, that I'm average and I'm typical and I understand how most people think. Now, all the jurors are going to walk in believing that. And as we get to shaping argumentation, we have to understand that. But I mentioned it today not because of the jurors, but because of us lawyers. The lawyers walk in with egocentricity bias as well. We believe that we understand jurors and what they're thinking and how to affect that thinking. And that leads us off on the wrong foot to begin with. We've got to begin with a humility that you're not average. You are much more well-educated, much more intelligent, much more knowledgeable about your content than anybody on that jury panel is going to be typically. And so we got to start with a level of humility that we don't understand them. So we begin with this concept of I've got to respect the data. You ought to have a ton of data off that prospective jury pool, both demographic and psychographic data that we can then use to decide who are going to be our good jurors and who are going to be those troublesome jurors that we need to focus on. Ignore your own belief systems and let the data speak for you, and you'll generally get better outcomes. So if you want to stop paying attention to the rest of the webinar and just remember this premise, you'll be much better off. But how do we get good data? Well, we start by understanding that people are very different, even within some subgroups. For instance, we take one dimension, individualism versus collectivism, and we find that it varies wildly just across the US. So the state of Hawaii and Oregon have very high levels of collectivism. They believe in a group ethos, whereas here in the Deep South where I live, in West Virginia, Alabama, Tennessee, Arkansas, they have a high level of individual ethos, a very bootstrap idea. So we can ask very similar questions to people that are otherwise demographically identifiable and find that they have very different outcomes across this one dimension. So we got to start by understanding that jury pool. So how do we do that? Well, the answer is simple. Let's start by researching. Now, luckily, because of the advent of the internet, we can now poll tons of people relatively cheaply within our jurisdiction and get an idea of what people walk into the room thinking about our case. And you can do that without sullying the jury pool in most jurisdictions. And even within jurisdictions with a small jury pool, some of the counties here in Alabama have 15,000 people left, we can do lookalike pools and survey those folks. So you can begin with a great set of data that lets you know not just what your argumentation looks like, but how that varies across the different people who are likely to show up. So we begin by gathering data. Then you start with the premise that demographics matter. And you likely know this, that there are variations off how people vote on juries depending on simple things such as their political affiliation, income level, educational attainment, and all those can be predictive in terms of outcomes. So at a minimum, if you're doing nothing else, you'll have this information to help you make better decisions. But there is a premise that you need to know that when we look at statistics, demographics are good, psychographics run circles around them in terms of their ability to predict who's going to be a good juror. And what this means, if you have two people that are the same gender, race, and economic levels, they may have very different views of the world. So we really want to get at how people think. That is much more predictive than purely demographic data by itself. The question is, how do we get at psychographic data? Well, we begin by understanding that it varies across demographics. So not all African-American females are going to think about the world in the same way. Not all affluent Caucasians are going to think about the world in the same way. And understanding that basic concept gives us the freedom to look at deeper sets of data to figure out who are going to be our better jurors, and so that we can identify those handful of folks that use our precious strikes on. So we begin in that surveying process by trying to get at psychographic information. And psychographic information tries to get at how they view the world generally. Now, luckily for you, there are about a half dozen well-developed, well-researched, highly predictive psychographic models that you can layer these questions into your survey. And you'll get surprising outcomes. For instance, we were part of a case recently, and one of the questions that was highly predictive was about the role of government. Now, mind you, the case had absolutely nothing to do with government, but their feelings about government were highly predictive of how they were going to feel about the topic at hand. So this question, do you feel like the government spends too much money? Seems pretty straightforward, but what we found that it was the variation within those subgroups was highly predictive of who's going to be a good juror for the plaintiff versus a great juror for the defense. And it was actually much more predictive than any of the demographic questions. So if you only had one variable that we were going to focus in on, this would have been it. Now, of course, we don't want to focus in on one variable because being able to stack variables is how you get to much better predictive outcomes in selecting a jury. So we want to ask lots of questions. I'll give you a few other examples that often are surprising results. So I'll ask you questions about your role in your interactions with other people. So the question is, when someone's close to you has a problem, do you tend to offer advice, try to fix it, or just listen? Again, what we find is that the outcome is highly related to civil awards. And it's simply across this dimension of likelihood to offer opinion. Now, if you saw this show up somewhere else, you probably wouldn't know what to do with it. But if you've done your psychographic research, you'll know that it can be highly predictive of not just their likelihood to vote for you, but their likelihood of giving a large or small award in civil trials. Another one that surprises folks are something that we call locus of control. The question is, do you think it's more important for society to prioritize order and rules or fairness and flexibility? So kind of two ends of the dimensional spectrum. What we found is that in a shocking amount of cases, this question was the most predictive variable out of anything that we mapped. This one is across the dimension of authoritarianism, your view of how people ought to behave, including yourself and everybody else, because it contains judgment about how individuals and corporations ought to behave. And in nearly every trial, it's one of the two that is the subject at hand. You can even ask questions that will be meaningless to your opposition once you get to the public selection of jurors. For instance, this one around a concept called locus of control is fate often gets in the way of my plans. Do you agree with this or disagree with this? The question gets at your view of, are you responsible for your own success or does other things happen? And this gets at the dimension of kind of the bootstrap people of I'm in control of everything that happened versus sometimes bad things happen. And what we find is that the outcome of this, again, is highly predictive if they're going to be in civil trials, a great plaintiff juror or a great defense juror. The upshot of all of this is to do your own research around your specific trial. It's relatively inexpensive to do the online research and you can get some tremendous data out of it. And make sure that you're layering in the psychographic questions so that you can profile the sort of people you're looking for and then build your voir dire questions so that you find out who those people are. Then we take all that information, we build written profiles. We're going to be the good jurors for us, we're going to be the bad jurors for us, and we weight each of those dimensions. Now, this is tough for us because as humans, we like to think that all weighting is equal. For instance, in a case I worked on recently, if you were younger than 48 years old, you're much more likely to be a plaintiff juror. Well, that was important. It was predictive, but it was only about 50% predictive, but locus of control was about 80% predictive. And so when you stack those features together, we could begin to score prospective jurors on a continuum. Because at the end of the day, that's what we're going to do. You have to not only list the factors, but weight the factors so that when we get to quantifying your jurors, we're building a model for each of them, because rarely do they end up at one end or the other, where somebody's a spectacular plaintiff juror or a spectacular defense juror. Most jurors end up somewhere in the middle, and those are the more challenging ones, the ones who have a probability matrix that leans us to one end or the other, so that we can map them across a distribution, and then you can decide, well, hey, who do I want on my jury pool? How am I going to use my precious strikes? And what are the probability that I'm getting the right folks? Armed with this information, you can begin to do challenge number one of selecting the right jury. Because remember, a successful trial often is shifting the jury pool from an 80-20 ratio to a 90-10 ratio, because we get a social dynamic that occurs that we can often overcome one juror that doesn't want to vote for us. But when there's two or even three, it often means our case is shot from the beginning. We're going to have difficulty overcoming that. So it's difficult to overstate the importance of being prepared walking into the room in your juror selection process, having a model, executing against the model, and scoring those jurors before you sit down and decide what to do with them. You're also going to be complemented with your veneer research. And what this means is once we get the jury list, you can go out and find out all the things about them. So my background is in marketing before I got into jury consultation, and it won't surprise you that we can find out absolutely everything about you. How you voted, how much income you make, how many kids you have, where you live, etc. And most prospective jurors post everything about themselves off of social media, which means that as we go and look on the common social media platforms, we can get a better idea of who they are, not just demographically, but psychographically. So before you ask question number one, you ought to have pretty good scoring of who the prospective jurors are and be able to focus in your limited time during your jury questioning off of the folks you want to get more information about. We also want to pair this with media monitoring to know what's being said within your market, your trial market, before a trial. Has our case come up? Has related topics coming up? What is the jury walking into the case about? If they're already primed about a topic, often because of some unrelated news story, you need to be aware of it because that will often color the perception of your juries about what justice looks like. Let's get to point number two. How do we predispose jurors to vote for us? And this is often the harder piece that often gets completely overlooked. Because from the time you open your mouth, you are coloring the juror's perception of not just your case, but you as an individual. So, what do we do about that? Well, we begin our preparation before we ever walk in the door. Well, we start by doing some favorability testing. Favorability testing is just finding out what do jurors think about you as an individual, because most law firms we work with have multiple attorneys that can help out with a case. And often the person selected to do the jury selection process is different than the attorney who will lead the case in chief. Why is this? It's because the dynamics can be very differently. During favorability, you want high affinity. You want the jury to like you and relate to you. They need to think you're friendly, memorable, and sincere. In the case in chief, they want to believe that you are credible and highly knowledgeable. Slightly different dimensions. So know how you score. Again, this is difficult for a lot of us because we have high self-confidence. We think that everybody likes us. I'm going to fit in great in every dimension. Know what you look like going in and then dress to fit that occasion. Think about what you're going to wear, the questions you're going to ask, and the demeanor you need to have because they're nervous walking into the room. They're uncertain of what to happen, and we want to create a likability before we ever open our mouth. So begin by checking the favorability of you or any other attorney you have on your team to know who ought to be leading this effort and have the humility to say, hey, not the right person for every single role. One of the recent cases we worked on, they had an attorney that was spectacular at this piece of the process, but only had a very limited role when the trial starts. And that was perfectly fine because by the time any other attorney opened their mouth, the jury liked their side and was predisposed to give them additional credibility. Then we got to begin thinking about how we affect the jury. Now, you know you're affecting the jury. That's a great overall concept, but how you affect the jury is a little different. So again, let's go back and begin thinking about some basic psychology. There's one principle in psychology called the commitment principle. And here's what the commitment principle says. It says that once you make a decision, your brain will rewire itself to think that it's a brilliant decision. A lot of research that goes behind this. Gambling. If I were to ask you who's going to win the football game, you might say, I don't know, 50-50 shot. But as soon as you make a choice, you'll recalculate your odds that choice is correct upwards to 70-80%, even though there's no new information. This really got highlighted a number of years ago off a game show that some of you, if you're old like me, might remember. It's a game show called Let's Make a Deal. The host was Monty Hall, and it was a show where people dressed up in costumes, and he would pull people up on stage, and the first thing they did was win something. He would give them a prize, and then a negotiation would begin to try to get them to select something different. So they were interviewing Monty late in his career, and they asked him, like, hey, what is one of the most fascinating human interest stories of your career? And he told one that was really fascinating. He said that he brought a woman on stage, and there were 3 doors like you see here, and he let her select a door, and she selected door number 2 and had a washing machine behind it. And he leaned over on camera into the mic and said, there's a car behind door number 3. Guess what she walked away with that day? A washing machine. Now, what's interesting is he gave her the keys to the kingdom. And he furthered that story by saying he was often shocked at how people were reluctant to change their choice once they made it. Now, modern psychology knows that's because of the commitment principle. Once we make a choice, we're predisposed to believe it was the right choice. So, what do we do within jury selection? Well, we're trying to get people to decide something early. When they do that, they will predispose themselves to believing all the further evidence that we're going to put forward. So we're beginning to influence jurors before we talk. How do we do that is a better question. Well, as we get to the how, we look at a related principle called the consistency principle. Now, the consistency principle says simply that we as humans are desperate to be seen as consistent in our beliefs, which means that if I say something out loud or write something in a public forum, I will realign everything else to try to be consistent with that behavior or that statement. Now, why is that? Well, it's because we as humans, particularly here in the Western world, really abhor someone that is seen as inconsistent. In fact, if you think about the most negative language that we have to describe other people, is often about them being inconsistent. We call them liars, cheats, betrayers, even politicians, if you really want to use a nasty word. And as a result, we are predisposed to not want to be seen as inconsistent. Now, with neuropsychology, we even have a better understanding of literally what's happening. Once we say something out loud about a belief, our brain literally changes our memories of that event to be in alignment with what we said. Think about that. If I can get you to say or write something, you will reorient your belief system to believe that it is true, and you'll be desperate for that to be consistent with all of your future behavior. Well, what does this mean? When you ask a question of that jury pool and they proffer an answer, all of a sudden in their brain, they're going to be worried about being seen as consistent. I'll give you an example of how powerful this is. I'm certain everybody on this call has stayed at a hotel at some point in the last few months. Well, when you went to go check out of the hotel, what question did they ask you? How was your stay, right? Well, what did you answer? It was fine. It was good. In fact, I don't really care. I'm in a hurry. That's why I'm checking out. If I had more time, I'd still be hanging out in my room. So it's kind of a social interaction that has very little meaning. Did you ever notice that they probably didn't write down anything regardless of what you said? Why are they asking you then? Well, they're asking you because the consistency principle, your brain literally will rewrite its own memory based off of what you said. And here's what happens. They ask, how was your stay? You said it was fine, it was good. And your brain immediately overwrites, well, I was a little irritated. The water wasn't as hot as I wanted it to be. Or maybe there was some trash in the trash can when I got in the room and I was a little annoyed at that. Or the check-in was slow, or whatever other irritations you have. And you will literally remember yourself saying that the room was great and your stay was fine. That's the power of the consistency principle. Some people call it the most powerful decision heuristic in psychology. It is the basis of extreme brainwashing. You get people to say things in consistent or in regular forums, and it will change some of the most fundamental belief systems. And it means that as we are getting jurors to answer questions at this phase, we're changing their own outcomes later when they're in the jury deliberation room. There's a closely related principle to this called the yes principle. And we're going to show you how we stack these two things. The yes principle simply says this. If I ask you a question and you answer yes to that question, you are statistically more likely to say yes to the next question, regardless of what it is. Think about how insane that sounds. If you say yes to a question, you're more likely to say yes to the next question, regardless of what it is. If you want to go look it up, the very specific theory is the question order bias. I like to call it the yes principle because that's really what it means. It means that if we want to get somebody to invoke the consistency principle, to say, yes, I believe in this thing that will help predispose them to voting for me, we need to be thoughtful about how we get them to answering that. I'll give you an example. If I start with a question that would be great to get people to answer to, but might be tough, something like this. Do you believe a company should still be held responsible, even if they didn't break the law, but people were harmed by their choices? Now, if I'm a plaintiff firm, man, would I love for people to say yes to this? Yeah. In fact, if I can get people to say yes to this, that's at the heart of a lot of plaintiff cases. But if I walk into a jury pool and ask this question, we're only going to get about 50% saying yes to that. And we know that most jury pools are closer to 80% going to be predisposed for voting for us. So I don't want to ask the question if I'm only getting 50% acceptance rate. So let me show you how we can think about the sequence of questions to increase the likelihood that they would say yes to this question. So I don't start here. We start with a question that is going to get nearly everybody, if not everybody in the jury pool, to say yes. has to remain topical. And so we'll say something like, do you believe there's sometimes a difference between what's legal and what's right? Well, it's one of those that no one wants to say no to because we all know examples of that. We don't think the law is comprehensive. We all fundamentally believe that. So what happens? Everybody on the panel says, yeah, I think that. And of course, I think that. Of course, the law doesn't cover everything. Well, then we level things up slightly, but on the same continuum. We ask another question. Have we all seen a company take actions that were technically legal, but still felt wrong or maybe even harmful? And everybody sits down and then they personalize that question. They think about some time that they got screwed over in a contract or an insurance situation or something else. And then they all raise their hands. I can think of a situation like that. And then we ask, again, leveling up one level higher. Do you think corporate executives sometimes prioritize avoiding liability over doing the right thing? And again, people personalize that question. And again, we have a high percentage of folks who will say yes to this. Now you can feel we're on the same continuum. Then we ask the final question before we get to the money question. You ever been frustrated by companies hiding behind the fine print? Again, same question of what we've been asking, but continuing to level up the commitment level, getting further along the continuum where we want them to say yes. And again, because we prime them these questions, they've said yes to all the subsequent questions. They're much more likely to say yes here because this doesn't feel like they're out on a limb. And then after we've gotten them to say yes, along the same continuum of questions, we can ask the question we really want to ask that begins shaping behavior. Do you believe they should be held responsible even if they didn't break the law, as long as we can show that people are harmed by their choices? Now I can get 90+% of the jurors raising their hand. And remember what we learned about the commitment principle. When they raise their hand or when they say yes in a group of people, their brain is desperately concerned about being seen as inconsistent. Thus, when they go into the jury room, they will find themselves wanting to defend this position that occurred before any evidence was ever heard. The punchline of all this is simple. Be very careful and disciplined about what you ask juries or the jury pool during the question and answer section, because you're shaping their own belief and behavior systems even different than what they walked in the room with. What I find is most lawyers like to wing it. They feel like they're good at it. They think they've got their key questions and then they're going to jump in. But a little bit of prep work can get you to much better outcomes. Somewhat related to this, we also believe that language matters. So the phrasing and terms that we have within our question and answer period is critical. Now, if you want to go research this, the Sapir-Whorf hypothesis simply means that we believe that language matters. Now, a lot of examples for this, and hopefully you've put together a language chart for your case of terms to use and terms not to use. I'll give you a few examples of that. In the case we worked on last year, we were confronted with the question, do we want to talk about the actions of the defendants leveraging a front group or a proxy group? They used both interchangeable, and they wanted to find out which one has more emotive power with potential jurors. So we did a little bit of research, and guess what we find? Well, front group conveyed something nefarious, something negative was going on, whereas proxy group didn't have that connotation. So front group wins in terms of the emotive power that it had. Thus, every time we asked the legal team to use this term, it was always front group. Similar question you may have exposed to at some point in college. Famous survey that asked two different groups of people, are you in favor of assistance to the poor? And they asked the same group or a different group of people, same question, are you in favor of welfare? You may be thinking to yourself, wait a minute, Jake, those are literally the same things. In fact, if you look up, what does the word welfare mean? It means assistance to the poor. But yet the outcome is wildly different. We ask people, are you in favor of assistance to the poor? 70% of people are like, yeah, man, I'm in favor of helping people out. In fact, we're a Judeo-Christian country. That's one that gets popular outcomes. However, same question when asked, are you in favor of welfare? Only about 30% of folks say they're in favor of welfare. And it's because the connotations, the emotional context of those words conveys much different outcomes, which means we have to be disciplined in our language and not just within our case, but in the phrasing that we use when we ask jurors questions. Another example of this comes with something in psychology we call the misinformation effect. And what the misinformation effect conveys is that the language that we use literally affects our perception of facts. crazy concept. I give you an example of it. So they ran some research where they brought some people into a room and they let them watch a video. And the video was simple. It was two cars crashing. They cycled the research the first time. They brought some folks in. They watched the video and they asked them the simple question: how fast were the cars going uh, when the wreck occurred? Well, they tallied the outcome and they found that the average speed was around, speed guess was around 35 miles an hour. And in reality, the cars were going about 32 miles an hour. So it was a pretty good guess. Humans aren't bad at sometimes subjective measures like this. But then they ran the experiment. They brought a new group of folks in. They showed them the exact same video and they asked them the question: how fast were the cars going when they smashed into each other? So they changed the phrasing from hit each other to smashed into each other. The changing of one word changed the outcome. The people in that second group also were asked to make a prediction of how fast the cars were going. Now remember, the cars were going about 30, 32 miles an hour. The control group thought the cars were going 35 miles an hour. Guess what they thought the cars were doing when we changed the word to smashed into each other? They raised their projection of speed to 50 miles an hour on average. That's a dramatic increase. Now, keep in mind, they were watching the exact same video. They had the exact same set of objective facts, yet they came to very different conclusions because of the language that we use. Now, think about this in your case. How often are we thinking about the language when we're putting on an expert or showing a demonstrative? We think the evidence is self-explanatory. In fact, I've reviewed it, it looks obvious. The expert reviewed it, it looks obvious to him. In fact, my paralegal looked at that and she said, yeah, that looks great to me. But the language that we use can change the objective perception of reality, and we're not giving it enough thought, particularly as early as the jury selection process. So as we're describing our case, the language that we use is going to have emotive power. It will change their perception of objective facts. It will change their own belief system. And perhaps most importantly, it will change their behavior once they're in the jury deliberation rooms. Now, got a whole nother topic we can dive onto about jury dynamics once they're in the jury deliberation rooms. The big factor you need to be aware of here is we've got to have a majority walking in. We can often use group dynamics to sway one, sometimes two jurors. Once it gets to three or more, we're out of luck. Thus, small movement can lead to big outcome. Give thought and discipline to the questions that you ask and the language that you use. The sequence of those questions can also convey a lot of additional power. Next, let's talk about narrative structure. So intuitively, you know that your case needs a narrative structure. You may not know that screenwriters think there are probably only about 7 or 8 different narrative structures out there, and they all serve different purposes to get different outcomes. If you've gone and watched movies, you think there's an infinite number of plot lines, and that is probably true. But in terms of narrative structure, there's many fewer amounts. We know that the human brain is predisposed for stories. In fact, we think it is the key to unlocking long-term memory. You ever try to struggle to remember a list of things? Maybe your spouse has asked you to get at the store, and then you get to the store and you're like, wait a minute, what was all of those things on the list? You have a tendency to remember the first things on the list and then maybe the last things on the list, the primacy and recency effect. Well, if you want to be good at memory, you turn it into a story. You tell a narrative, and that narrative structure is much more sticky. The other beautiful thing about narrative structure is it conveys morality information. And I'll give you an example of how this works. We start with an intentional story structure, and this is one of the most common. So we've got to have an event that started what happened. We have rising action that leads to a climax. That's when the pivot point of the case is occurring. Then we show the outcomes of that, the falling action, and ultimately the resolution. And in the case of a trial, the resolution is often what we're asking the jury to do. So it's a format that the brain will be familiar with, and they expect to get information served in a set way. Now, this information, when served in a set way, allows them to remember it, but also it conveys morality information. What do I do with this information? Have I heard this story before, and do I know how this story is going to end? Because let's go back to the beginning part of today's presentation. Remember System 2? It's effortful because it burns calories. We don't want to think. The upshot of this is that the brain is looking for simple answers to complex questions. We've already agreed that the case you're going to present is probably fairly complex. It is not the run of the mill case. It's got unique facts to it, and that's why it's probably ending up at trial. If it's complex, we know the jurors are looking for simple answers to complex questions. Serving up our case in the form of a narrative, particularly in the introduction of our case to the jury in voir dire, gives them a narrative structure that contains both information but also decision criteria, how they need to feel about the outcomes of this, and will predispose them to voting for this. Now, there may be an infinite number of stories we can tell, but there are fewer morality tales that we can tell. And we need to be disciplined about the ones that we select in terms of serving up to the jury. I'll give you an example of powerful morality tales. We'll take The Wolf in Sheep's Clothing. Now, I'm a dad. I've got 4 children at home. I have probably read The Wolf in Sheep's Clothing at some point in the last few years, but it's probably been at least a few years. For some of you on the call, you may not have children, or maybe your kids are fully grown. You probably haven't read The Wolf in Sheep's Clothing in a decade, 2 decades, or perhaps not since you were a child. But if I ask you to tell the story about The Wolf in Sheep's Clothing, you'll probably get it. You may not get all the characters right, but you get the fundamental idea. There's a herd of sheep, and a wolf manages to get a sheep's outfit and shows up, then demolishes the herd. And you'll be able to understand that it conveys a morality tale. Who's the bad guy in this story? Well, it's obviously the wolf. And why is he the bad guy? Well, he betrayed the trust of the sheep by being this secretly sneaky bad guy. And then what's the morality conclusion? What needs to happen to this wolf in sheep's clothing? Well, he needs to be punished. He needs to be dealt with because he's super dangerous, and we can't allow that to happen again. So to use this for a framework of a story, it not only lets you know what information, what evidence is going to come into play later, it contains a morality tale about what you need to do with this information, what we need to do with the characters in this story. And all characters, whether they're plaintiff or defense, a story to tell. Choosing the right story is critical to getting successful outcomes. Now, this isn't just Jake's opinion based off of prior psychology research. We've actually tested this methodology with prospective jury pools and want to illustrate that we actually do get significantly better outcomes. So we used a real case and told it in several variations with a neutral version of the case, using a narrative structure, in this case, The Wolf in Sheep's Clothing, and one that used a version of the story that the lawyer selected. And what we found is that the Wolf in Sheep's Clothing narrative tale got dramatically higher outcomes in jury award. Nor did they win more frequently, but the total award that they were given by these sample jury pools was much higher. Why? Well, that's just like we talked about. The brain's looking for simple answers to complex questions. By giving a strong narrative structure, it allows them to know what information is coming, know when they hear information, where it fits into the story, and then what to do with that story, how it ought to end up. That's why story structure is very powerful. And it's also one of those things we often don't give a lot of credence to because we feel like our case is self-explanatory. But remember, people don't want to be thinking. Often trials end up over the course of several days, sometimes as long as several weeks. And the thought we're going to have people's attention over a long period of time is silly. But it also means that when we're first introducing the case and they're only hearing about snippets of it, we need to make sure that we have our story boiled down and can convey it in a very short format. If we can do that, we can begin predisposing the jury to vote for us. So they hear our version of the case, we ask them questions in a structured manner, being disciplined about our language, and then we get their public response. And them to give a public response changes their own belief system, changes their own memory about what they believe, and will influence the dynamic of once they get back to the jury room. Now, what's critical is to circle back and think about taking those two things together. We're trying to both select the right jurors, figure out who those 1 to 2 folks are that might end up on a jury pool that are going to be troublesome for us, or our big advocates if we're the defense. We want to make sure those folks end up on the jury pool. And we know that those 1 to 2 jurors can often sway things. So we start by doing our research, walking in with not just demographic information, but psychographic information, because psychographic information is more predictive of jury behavior. We're going to build a profile before we walk in the room so that we've got an idea of what we're looking for. That allows us to put our own biases to the side, because we certainly walk in the room with our own biases. Then it allows the data to speak for us. When we can, we'll do We use the veneer research so that we get additional data off that jury pool, so that we've got some statistical data based off who they really are, readily available because of marketing databases. We can look at their social media accounts, get information about how they really behave. Then we're going to use that psychographic information to think about what we want to ask, to profile those jurors. So we start with some information. We've got a pretty good idea if we're going to be our good jurors and our troublesome jurors. It allows us to focus in our limited time on getting information off the folks we're not certain where they're going to end up. Then we use that information to score the jurors and weight them. That gives us a better idea of how we want to use those very precious strikes to make sure that we get a great composition of a jury panel. At the same time, we've got to use that limited time to predispose them to voting for us. Can we get them? How do we predispose them to voting for us? Again, we prepare before we walk in the room. We think about what we're going to ask when we talk about the case, what the narrative structure is, what questions we ultimately want them to say yes to, and how am I going to get them to say yes to those questions? Because it is a sequence. We can leverage psychology in getting people to an outcome, because once they make a decision, it changes their mind. Once they do it in a public forum, it locks them into that position, so that when they're in that back room, they remember your narrative, which sets you up for success during the trial. They'll know from your narrative structure what evidence is important for me to remember. It contains morality information. What do I do with this evidence? Because it gives an inclination for what the outcomes ought to be. If we can do both of those things at the same time, help us select jurors and help predispose those jurors, it allows us to begin stacking the odds where we get better outcomes. Because trials boil down often to 1 to 2 jurors on any given jury pool. If it were worse than that, we probably don't have a winnable case if we're a plaintiff. If we can get more than that as the defense, well, we feel pretty good about being able to get a good outcome, or unable to get the troublesome jurors over the hump. But we've got to make sure that we're taking advantage of case structure, narrative, and language to predispose those jurors to voting for us. So it's these two principles, by leveraging psychology, that allows us to build a case. So, reminder about how all this fits together. We're trying to apply basic human psychology, and it starts with understanding how we make decisions, that we're not rational, that there's system one, system two. And we apply this by getting better market research, by crafting the messages of our case, simplifying our case so that we explain it very simply and directly using the right language during jury selection, all the way through prep and even into post-trial. If we can do those things, we can get dramatically better outcomes, even without changing the facts of our case. And that's really our task in the legal industry, is how do we use all of this to get better outcomes? If you have enjoyed today's content, know that we put out a ton of content related to psychology-driven marketing. This is a QR code that will take you to our page where you can subscribe to our newsletter, and you will get regular updates of psychology and how it applies to the legal industry. We've tried to save some time today because I know there are going to be a lot of questions. So if you have not, go to the Q&A tab on your browser and submit questions. Nina will organize those questions, and we're going to spend at least 10 minutes here at the end answering questions so that you can get a little bit more out of this. Normally, when we do this, we have far more questions and your case is far more complex, and we can cover it in this forum. So I'm also going to give you my email address as well as our social media handles. So feel free to go and ask me and dig in additional questions about your case. It's happy to help out. If you are an attendee of today's meeting, I'm happy to give anybody an initial screening call and give you some initial thoughts on your case. Just set up time to chat with us, and we'll be happy to give you our initial thoughts. With that said, Nina, I am hoping we've got some great questions that we can dig into.
Definitely. Thank you so much, Jake, for that presentation. Now we can go ahead and dive into questions. As Jake mentioned, if you have some, please feel free to submit them by clicking the Q&A button in the control panel at the bottom of your screen. So we already have a couple. This first one is, can you explain how the techniques that you mentioned can be used in a criminal trial setting when specifically representing a defendant?
Great question. We get this a lot, as you might imagine. Same principles apply. Let's start by understanding what the jury pool is going to walk into the room thinking about this trial. That allows us to not only shape your argumentation, which is going to be critical, but evidence of innocence allows us to put forward or create significant doubt. But it also allows us, more importantly, to begin profiling who are going to be the jurors that we want on that panel. Because particularly in a criminal trial, one or two key jurors can help us get a good outcome of a hung jury or a not guilty verdict. So same concepts apply. So begin by doing your research. Luckily, doing research is very inexpensive. We can run a survey for as cheap as a few $100s. That allows you to get data to let you know what people think about your case and begin to profile those good jurors. Same principles apply in jury selection as in civil trials. Be prepared. Think about how you're going to talk about this case, how you're going to frame this case, because regardless of what it is, there's a story to tell. There is a morality tale that you can relate to. It's about mistaken identity or reasonable doubt or innocence or what really is justice. And make sure that you're framing things in a certain way. You're getting discipline to your language, because I assure you the prosecution on the other side has done this. It's not for your specific case, but because they do this professionally. They think about their language a lot. And you have to be wary about falling into their language cues, but rather using your own language cues. Same principles apply when you're questioning a jury. Make sure that you've got a sequence. We've got some key questions we want to get them to say yes to. This, you're beginning to predispose them to vote for you, to create doubt before they ever hear the first piece of evidence. Because as soon as they hear about the case, they're beginning to form opinions. So think about how you want to frame the case, the language that you want to use to begin shaping outcomes.
And thank you for that insight, Jake. Our next question is, do you feel that there might be ethical issues that could arise when using digital data to evaluate jurors? Is that something that they should be aware of?
Great question. Let me start with, I am not an ethics professor. I will tell you that all the things we have talked about here today have been used in marketing for many years. Now, working in the legal industry, I believe, probably like you do, that the quality of the lawyer can affect the outcome of the case. So it's the same question. Can we do things to affect the outcome of the case? Now, I can't get somebody in marketing nor in legal to radically change their belief system in a short period of time. What we're doing is nudging around the edges, getting people that might fall one way to slightly change their opinion by how we're framing information. So understanding who I'm talking to is absolutely critical. In fact, I think it would be a disservice to our clients if we didn't take that extra step. Why? The data is available. I mean, we're using it to sell potato chips and shoes. Certainly, we can use it to help shape our argumentation in a trial. In fact, I would think it might be a disservice to our clients if we didn't use that information, because I assure you the other side will be checking that information.
Thank you, Jake. Our next question is, do you have any more examples of sentiment analysis predicting juror bias? Could you please share those if so?
Uh, Yes, it is the short answer. So I've tried to pick a few examples today that are often surprising to people. Usually when you hear those questions, you're like, that's nonsense. I don't know what to do with that. What do you mean locus of control? Do I believe I control my own fate, or sometimes fate happens to me? Every time I ask that question of a lawyer, their eyes kind of glaze over like, I don't know what to do with that. I'm not sure I'm going to ask that. But when they see how highly predictive that case can be, or that question can be in some cases, it changes their behavior. In a case we worked on recently, it was the single most predictive question we had in jury selection. In fact, it was almost 90% predictive. And what it did is it allows us to break apart some of the demographic information, because they thought, hey, maybe African American females that are low socioeconomic, who are single moms, are our best jury profile. But what we found is that in talking with them, those are not a homogenous group. There's no real thing as a homogenous group. People are people, and you're trying to get at how they think, because that is more important than how they unify them. We use about a half dozen different peer-reviewed question sets that are highly predictive. And we often use those when we're doing online surveys. We select the set of responses based off of the topic at hand so that we can get the best outcome. Then we take the academic sounding questions that happen in the jury and we turn them into questions that will sound normal to you when you're in a voir dire setting, so that you're asking the jury, it'll sound natural coming out of your mouth. Because you can't say, who in here has a high locus of control? You might say, who in here believes that sometimes fate intervenes in their plans? That sounds like something I might actually say. But the outcome is tied to an academic question that is highly predictive. Now, these aren't questions that I've made up. These are questions that a psychologist made up and did tons of study and has been reproduced many, many times in their correlation to their behavioral psychographic outcomes. And that's a key part of this. Don't make up your own questions because sometimes you'll get answers and the questions may not be predictive. And that's also a tangent here I didn't have time for that AI is the same issue. If you ask AI a question of how people are going to respond, it will give you an answer. Is that answer predictive? Sometimes. Is it always? No. So be careful about what you're asking and how much weight you give that answer. Make sure that you're relying off things that have been studied and that are predictive.
Thank you, Jake. And then this next person asks, how would you recommend adjusting juror profiles during voir dire based on their real-time responses?
Uh, Great. So what I would encourage you to do is you walk in the room with a profile of your good jurors, your bad jurors, and you will have gotten information off of them before you ever open your mouth. So you will know, even if you didn't get veneer research ahead of time, if you're walking in, you will have gotten a jury survey from the court. And so you will know often income levels, job, educational attainment, and lots of information. Use that information to go ahead and pick out the ones that we have said are predictive and then score them on that. And that will leave you with a handful of things that you want to then dig in and ask. So we go through 2 rounds. Before you ever open your mouth, let's score jurors. And that puts people into 2 camps, the folks I'm worried about and the folks I feel pretty good about. And usually you want to spend your time honing in off of a handful of jurors to figure out, all right, demographically, you profiled like somebody that's pretty good, but let's check and make sure. And so you ask a handful of questions that are very revealing. And as they're answering questions, you or one of your peers or a firm like us needs to be scoring them. And we weight those answers to give a final score. So this juror is a 90, which means they're going to be a great plaintiff juror. This juror is a 5, that means they're going to be a great defense juror. And that allows us to know when and how we want to use our strikes, as well as how we need to shape our argumentation once we get in the case in chief. Because sometimes you can't help what happens. Sometimes you can only strike people in the order they come in, and you're going to end up, even with your best efforts and best research, you're going to end up with some folks that end up on the jury pool. So you want to also use that information to know who you need to be pitching and how you need to shape your argumentation to appeal to them. Because if you're going to win 80% of the jury to begin with, don't waste your energy on them. Spend your energy off of the 20% that is troublesome. And that's a different way of thinking about juries in the profiling and selection. So walk in prepared, score them dynamically, and then use that information to try to get a better jury pool.
Thank you, Jake. We have a couple questions about presentation styles. So, one anonymous attendee asks, how can lawyers avoid seeming manipulative when tailoring their delivery? And then another person asked a very similar question about how to improve presentation style during voir dire.
So great question. We do a lot of presentation coaching, as you might imagine. And one of the things I want to get across is don't try to change yours. Very few of us are good enough actors to portray different fundamental styles. And you likely have something that you're really good at. So what you want to begin by doing is understanding what you're really good at and how that is portrayed. So let's do some testing. Again, we can do that in an online survey pool and find out how you're viewed by different groups of people. Then in the voir dire, you want to make sure you're selecting the best person for that very specific task. Then when you get into the case in chief, make sure that you're taking your style of presentation and matching it up to the part of the case that is a best fit for your presentation style. You need to lean into it because you're not going to overhaul who you are. You can tweak around the edges. So compose your team so that you've got the right complementary style for what you're trying to accomplish. Some teams have somebody who's a specialist in the veneer because they're highly relatable. They can walk out with everybody going, man, I like that woman. I want to vote for her before they ever know anything about the case, just because of their presentation. And then separately, if you want to talk about how to get better at presentations or figuring out your style and leaning into it, that's a whole other topic that maybe Nina will invite us back for another time.
We would absolutely love to. Thank you for that additional insight, Jake. Our next question is about choosing different attorneys for different phases of the trial. So you kind of mentioned structuring that differently. So this person asks if there's any stats on if a jury receives someone well during voir dire, but then maybe doesn't for trial or closing statements. How do you differentiate that? What would you recommend?
So whole nother presentation topic to cover this. And yes, there is research that goes into this. And I will start by acknowledging sometimes we have constraints. There's not an infinite number of lawyers at your firm for us to choose from. And there will be somebody that is going to be the lead attorney on a case because they know the most or are considered the best litigator. And so sometimes you have constraints of who's going to do opening or closing. Often you're working around the edges. So the voir dire, we often have somebody doing something different and interviewing different witnesses. We want different roles. Sometimes we have a witness where we need to feel sympathetic. So somebody that has a style that's very harsh is the wrong person. Sometimes in cross-examining a witness from the other side, we want a different style. And so you want to lean into that. Fundamentally, we know that jurors will respond to different types of lawyers and presentation styles, and in the best of cases, you have a diverse team that's not composed of, say, all old white dudes, which I've seen before. We want to have broad representation because that's what the jury pool is going to look at. But they all walk in with different perceptions of what each of those roles mean. One of the more famous ones is that somebody has a British accent. Americans think that they are more credible. Can't do anything about that, but acknowledging what it is allows us to know when and how to use that. How you may not have somebody with a British accent, but chances are the folks on your team have Southern accents and Midwest accents and maybe a Long Island accent. And so adapting to your style and what they think about you, down to what you wear, the ties that you wear, the glasses that you wear, how much eye contact you make, all those can affect how they're going to perceive you. So again, start by understanding of how you are perceived, what role you play, what you're good at, and then lean into that.
Thank you, Jake. Our next question and our last question that we have time for today. Again, if you have other questions, you can always get in contact with us. We're happy to facilitate your connection to Jake, or you can refer to the contact information that we had up previously. So our last question for today is really about giving jurors a peek behind the curtain. So this person asks, do you recommend highlighting for jurors how lawyers may use these techniques, such as word choice, to cast doubt on your opponent?
Sure. So one of the most underutilized components of putting on your opening statement is framing the opposition's case. And framing the opposition's case is a critical component of kind of laying landmines where they have a chance to present their case either in chief or respond to your case. I don't know why, but lawyers omit that or think that they can't do that. And so you absolutely need to do that. And so if you feel like they're going to be using choice language, call it out. It doesn't completely disarm humans from the effect of some of the things we've talked about and to kind of decision heuristics generally and other topics that we can cover in other webinars, but it can diminish it a little bit. So calling out some of those things can be very effective. But framing how the other side is going to either defend the case or prosecute the case can be super effective because it makes people aware of their own biases as well as kind of the perception of being manipulated. Because this won't surprise you. In criminal and civil trials, jurors walk into the room super skeptical. They do not like lawyers generally. They don't like anything about the process except for the police officers who may be in the courtroom and the judge behind the bench. They usually have high levels of respect for. So you're already going to have to overcome some of that, but you can also use that when talking about the other side and leaning into some of the preconceptions about those of us in the industry.
Awesome. Well, thank you so much, Jake, for your presentation and answering all of our audience questions. And thank you all so much for submitting your questions. We really appreciate your participation. We want to thank you again for joining us for another Justia webinar. As I mentioned earlier, if you're a lawyer attending today, don't miss out on our Justia Lawyer Directory, a free tool to boost your professional presence. You can claim your profile at lawyers.justia.com to connect with millions of potential clients. And if you want even more visibility, you can always add on a Justia premium placement to show up above those organic listings. If you'd like to learn more about that, you can go to marketing.justia.com. Thank you all so much for your time and have a wonderful rest of your day. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.